Hi, my name is Bill Brush, and I'm the president and founder of Cut Unnecessary Regulatory Burden. Many folks have asked, what's this lawsuit all about? Why did Apco sue Nissen in federal court? And that's the subject of this presentation. And we're going to try to do it less a lot of legal jargon and try to explain it in layman's terms so that everyone will understand. Last October, Apco filed a lawsuit in federal district court against the Nissens. They cited 3 claims, and we're going to explore each and every one of those claims in a little bit more detail in the next few slides. Apco wrote in its lawsuit that the Federal Power Act, the FERC license order, and its SMP granted it authority and responsibility to regulate all uses within the project boundaries, including Nissen's property. Well, this is mostly false. The only true thing in this statement is that Appalachian assigned itself the responsibility to regulate these uses by agreeing to its license. Apco's license only applies to the lands Apco owns and controls, just like the SMP can only regulate lands Apco either owns or controls. In this particular case, Nissen owns his lands in fee simple, and Apco only holds a flowage easement to flood a portion of his property. Any authority that Apco claims that it has is via its property rights, and they can only enforce those property rights in state court. In this claim, Appalachian's saying because the Nissens did not seek Appalachian's permission and agree to the terms of their permit, that Nissens are in violation of their license and the shoreline management plan. Well, let's talk about the reasons why Nissens didn't sign that permit. First of all, they don't need permission. They don't need the permit. Their property rights give them the right to build that dock, to remove vegetation, and to construct pathways. Appalachian's permit is a tool to extort Nissen of his property rights. In this case, it's not a threat. They actually took him to court. And they're claiming in the court that FERC gave them the authority to do that. That's not true. FERC gave Appalachian no authority to force anyone to sign an agreement that takes their property rights away. As a third-party non-licensee, we know that Nissen cannot violate Apco's license or shoreline management plan. So this claim is, again, completely false. The third claim, they said that the defendants violated the flowage easement agreement. Well, let's review that briefly here. First of all, the landowners granted Apco the right to flood and clear the lands within the project boundary for one purpose: for construction, maintenance, and operation of the dam and the power station. There's no mention in the flowage easement of a federal license or an SMP. And if it's not mentioned in the easement, it's not part of the easement. It doesn't exist. You can't add it later. Meanwhile, the landowners retained all the rights to their property to use it as they want it, as a fee simple owner, so long as their uses didn't impair Apco's flowage rights. That's been reinforced by the Virginia Supreme Court in at least 3 lawsuits, so we know that's correct. And the flowage easement runs with the land title forever. So, again, we conclude that Apco's claim, number 3, is totally false. Appalachian likes to say because it has a federal license, this is a federal case. Well, that's not the case. This is the rule for cases filed in the Western District Court of Virginia. A federal question is one that alleges a violation of a federal law, either a statute or a provision of the Constitution. Nissen clearly isn't violating the United States Constitution by defending his property rights. And we know that the Federal Power Act, that is a statute, but we also know that Nissen can't violate it because it only is an act that pertains to Appalachian and the FERC. If anyone's violating the United States Constitution, it's Appalachian Power, because what they're trying to do is steal from Nissen, extort from Nissen his property rights without compensation. That's a violation of the 5th and the 14th Amendment of the United States Constitution. So what's Apco doing here? They're fabricating some false federal jurisdiction so they can stay out of state court where they've already lost. We know, again, the Federal Power Act only applies to FERC and its licensees, period, and that Nissen can't violate it because it doesn't apply to him. Apco continues to claim that the flowage easement gives them the right to clear and remove anything within the project boundary at any time. Well, that's not true. We know that when the landowners granted Appalachian the right to flood, it also gave them the right to clear the land within the project boundary for the construction, maintenance, and operation of the dam and power station. Not for shoreline management reasons, not for other federal license reasons, because these were not part of the agreement. What Appalachian's doing here is distorting the meaning of the flowage easement with a dishonest reading in order to confuse the court. We know the Virginia Supreme Court in at least 3 separate occasions has established the limits of Appalachian's flowage rights. What they said is that fee simple owners of the land can continue to use their property for any reason they want to, so long as those uses do not significantly impact Appalachian's ability to flood their property. Let's briefly review what the flowage easement truly says. The first paragraph establishes the scope, the reason for the flowage easement. And when you read that, you see it's only for the construction, the operation, and maintenance of the dam and the power stations. In exchange, or for the above mentioned considerations, the landowners hereby granted Appalachian the right to enter upon their land and remove any buildings, structures, or improvements that would interfere with the construction, operation, and or maintenance of the dam and power station. That's what it's for. That's what it means. You cannot find shoreline management plan reasons or any federal license references. Well, now Apco's claiming that a previous ruling in the Arthur case shows that this court has already determined that Appalachian's flowage rights are sufficient to regulate and control Nissen's property. That's not what Judge Urbanski said. Let's read what he said. Defendants, meaning the Arthurs, have not contested that their property rights are subject to Apco's flowage easement deed, and they've offered no argument that Apco's property rights are insufficient. Thus, the court concludes that Apco has sufficient property rights with regard to the Arthurs' property. Well, what that says is because the defendants didn't raise the issue, the judge didn't consider it, and consequently simply relied upon Appalachian's certification to the court that it has sufficient property rights. Not exactly justice, but that's the way the court system works. It's not about justice, it's about legality. And the judge was proper in this ruling by saying, if you didn't bring it up as an issue, I can't consider it. Had the Arthurs challenged the insufficiency of Apco's flowage easement, the court would have considered it. That's exactly what Nissen is doing here. He is challenging the sufficiency of Apco's flowage easement to regulate his property. So therefore, the Apco versus Arthur case has no precedence or no value in this particular case. Again, one of the latest claims is, and this is bizarre, Nissen has no standing to argue the sufficiency of Apco's flowage rights, because really that would be a collateral attack against their license. So let's understand this. Apco can claim that the flowage easement gives them all the rights they need, but Nissen can't argue against that. Well, remember, FERC directed Apco to resolve property disputes in state court. What's happened here is Apco's simply manufactured federal jurisdiction by filing against Nissen in federal court and misrepresenting what the flowage easement says and misrepresenting that federal jurisdiction pertains here. I use the laugh test. How can anyone make that statement that Nissen cannot argue against Appalachian's claims that the flowage easement is sufficient to regulate Nissen's property. It doesn't pass the laugh test. Here Appalachian claims that since Nissen purchased the property after FERC ordered the new SMP, that Nissen's can't allege a taking of rights, that the taking took place before he owned his property, therefore he's not eligible for any compensation. What's Appalachian really saying here? Are they saying that the new SMP took property rights from Nissen? If that's the case, that new SMP took property rights from everyone, and consequently they owe everyone compensation for the taking of those rights. It's a bizarre argument because we know that the property rights can't be taken by a shoreline management plan because those property rights are deeded and flow with the land. We know FERC has told us that a shoreline management plan can't change property rights. The only way property rights can be changed is through mutual agreement between Appalachian and the property owner. Well, again, Appalachian uses a permit. It's a fraudulent instrument. It really extorts property rights unlawfully under fear that they're going to sue you and telling you at the same time that FERC gives them this right. That is not true. This argument, it's bizarre. It doesn't pass the straight-face test either. Well, let's sum things up here. What have we learned? First, Apco has no regulatory power over property owners other than through its property rights. And in Nissen's case, they don't have the property rights to tell Nissen how he can use his land or whether or not he can build a dock. They only have an easement, which gives them the right to flood a portion of Nissen's property up to the 800-foot contour, period. They have no authority to deny Nissen access to the waters, nor do they have any right to dictate how the landowners use their properties. That's exactly what the flowage easement tells Nissen he can do. He can use that property for any purpose so long as it does not impair Appalachian's ability to flood the property up to the 800-foot contour. And we've learned that FERC has told AEP to settle these things in state court because property rights are a state issue. But instead, Apco has manufactured federal jurisdiction by filing a case in federal court against Nissen, arguing that its federal license gives them the right to do that, and arguing that the flowage easement deed is superseded by the SMP regulations and their license. None of that is true. Well, now that we all understand what this lawsuit is about, what can we do to save our property rights and prevent Appalachian from continuing to file these bogus lawsuits against property owners? Well, support C.U.R.B with a financial donation. C.U.R.B is a 501c4, not-for-profit Virginia corporation whose mission is to educate and inform property owners here at Smith Mountain Lake and any place about the importance of your property rights. Your donations are not discoverable, and portions of your donations will support our educational efforts as well as help offset some of the legal costs we're incurring defending against Appalachian's bogus lawsuits. Thank you.